Welcome to TLD Talks, where we share key insights about legal and business matters that are impacting SMEs today. Bringing together experts from a range of backgrounds, we tackle the issues that matter to you. I'm Ed Simpson, founder of The Legal Director, and recently, Client Legal Director and Employment Law Specialist Kate Palka gave the second of her excellent webinars on the latest very significant changes in UK employment law. We thought it was so relevant to all SMEs that we wanted to incorporate it into a special episode of the podcast. I hope you enjoy it.
Hi everyone, welcome. Thanks for joining us. So the Labour government's been talking about its manifesto, Plan to Make Work Pay, since early on in its bid to become the governing party. Now in government, right up to the wire, they promised to introduce this employment rights bill in the first 100 days. And it finally landed on the 10th of October. It's a bill, so the journey into law is a lengthy one. The government expects to begin consulting on the reforms in 2025, and it will be seeking significant input. So you'll all have a view, I'm sure. So please do feel free to enter into consultation. And you'll see why some of these changes are significant and may affect your businesses significantly. So what I'm going to do is just go through the main headlines of what the bill is seeking to introduce and outlining what the implications might be, what you can do to prepare. And if I've got time, right at the end, I'll talk about what the government is saying they're going to be doing in due course. These measures, though, that we're going to talk about in the next half hour are pretty much certain to become law, but they're subject to a lot of consultation. So they call it the biggest upgrade to workers' rights in a generation. It's 150 pages long, 28 employment measures. I'm only going to be dealing with some of these. If you had trade unions, then you might need an extra half an hour on that. So I'm not going to touch trade union law. And as I've said, consultation on most of it is to start in 2025. A lot of these changes are in relation to timing. And the most significant one that I'd like to talk about is that of unfair dismissal. So at the moment, most employees, all employees need 2 years service eligibility to bring a claim for unfair dismissal. And I'm sure you're all aware of that. I have been around an awfully long time, and I remember when there was no service eligibility, when there was 1 year, when there was 2 years. It's a political football. And now the government's come back in. There is no surprise that they are changing it back away from greater protection for employers and giving employees greater rights. At the moment, I get a lot of calls from employers saying, I've got an employee, I want to get rid of them. They've only got, say, 10 months service. I don't have to do anything, do I? In terms of process, I can just ring them up and tell them they're out. It's a dangerous strategy that there may be, they could bring a claim for discrimination. And of course, they don't need the 2-year eligibility service criteria for that. There is also no legislation on probation periods at the moment. And what we've got is a hodgepodge, really, of people either taking notice of probation periods, making them really work for them, or ignoring them completely, or not using them at all. What the government have now said is that employees can bring claims for unfair dismissal from day one. And there are a couple of reasons why they could bring a claim beforehand. For example, if they were not given a job because of their political beliefs, but that's a detail. The most significant change is that from day one, employees will have the right to bring a claim for unfair dismissal. So it's a significant change. What the government is saying is that, the idea behind this is that statutory probation periods will be used in a meaningful way, in a way that they're not used at the moment. They're talking about 9 months for an initial period of employment, as it will be called, during which they will encourage the parties through proper processes to assess performance. There'll be prescribed dismissal reasons during that period. Notably, redundancy is not one of those reasons. Redundancy is taken out of this process. You will still be able to make redundancies, obviously, but there'll be a different process. But you'll still be looking at capability, for example, or misconduct to dismiss somebody within that 9 months period. The government have said that there'll be a lighter touch process. So you won't necessarily have to go through the full disciplinary process that you do at the moment with an employee with over 2 years service. But there will be a process. It will include, for example, having a meeting with the employee at which they can be accompanied. As I've said, it's not applicable to redundancy or reorganisation. And what the government have also said is if there is a dismissal within that IPE, the initial period of employment, which a tribunal says is unfair in the sense that the process wasn't gone through properly, if the employee is going to get compensation, there will be potentially lower compensation. So those are the headlines. There are no details yet around this. So what we're looking at, though, is a day one right to bring a claim for unfair dismissal. So how can you prepare for this? I would say there are a couple of areas. First of all, in preparation and recruitment, ensure managers are already managing new hires to spot underperformers. I'm sure they're all doing that, but actually you're going to need to be much more focused and organised about how you show that somebody is underperforming. So training managers to deliver consistent rules on reviews and dismissals now so that good practice is embedded. Update policies on performance, conduct and sickness absence to nip poor behaviour in the bud. It's one of the hardest things to do. You have somebody who's not behaving, turning up a bit late, it slides and it becomes habitual. It's not nipped in the bud. That won't be possible now. It won't be possible to dismiss them without going through a proper process. Develop recruitment and selection processes in terms of application, interview questions, appointment documentation. When they arrive, give them clear induction processes with expected values and behaviours and triggers. So you can look at your the triggers, for example, after which they will be in a process if they're turning up late. Explain the probationary review period, be clear on reporting lines, and get them to do their training. Probation periods in themselves, as I said, some employers use them really well, others don't use them at all, and a lot are in between that. The probationary period that the government's talking about is 9 months, but it is under consultation. But what you can do now is make sure you've got a clear probationary review process in place. So you can have, for example, reviews at 4, 8, 12 weeks, then 6 months, and then 9 months. Detailed forms. Make sure your managers are capturing the evidence in a way that they may not be at the moment. Train them to deliver consistent rules on reviews and dismissals. Train them to understand triggers when employees could fail their review. And train them to understand the steps to be taken to exit an employee post a failed probationary period. And in terms of performance management, you could review your performance management system or indeed develop one if it doesn't exist already. A performance management system will be key because that will be part of your fair process once the day one rights kick in. As I've said many times, train the managers, upskill them on how to manage underperformance and ensure your documentation is in place. Another day one right change is to SSP. So currently SSP is payable from day 4 of sickness. And there's an earnings qualification minimum of £123 a week, and it's payable up to 28 weeks. It will become a day one right in the sense that SSP will be payable from the first day of sickness. Many employers' hearts will sink at this one because we all have employees who take the odd day here and there, but many employees won't do that, even if they wanted to, because they won't be paid. From now on, when this change comes in, they will be paid. Furthermore, the lower earnings limit will be removed and SSP will become the lower of a defined percentage of weekly pay, or £116.75. Another day one right is in respect of parental leave, and there are changes as well to paternity and maternity rules. So currently, certain rights, for example, to take paternity leave, only apply after either 26 weeks or 52 weeks for parental leave. And in terms of bereavement leave, at the moment, the only people who have a right to take bereavement leave are parents when, sadly, their child dies. The changes here is that they will all become day one rights. That's the right to take paternity leave, unpaid parental leave. And additionally, bereavement leave will be expanded so that it's available to all employees for a bereavement. It doesn't have to be their child. If it is a child, they're entitled to 2 weeks. Otherwise, it'll be 1 week. Additionally, there'll be new protections for maternity returners. You'll probably all be aware that for redundancy situations, somebody who comes back now after maternity leave has the right to be offered any available alternative job. That's recently been extended in April by this government. Maternity returners are getting further rights under this proposed bill, which will be the right not to be dismissed for 6 months after return. This is on top of the new rights of redundancy protection. So in terms of people going on maternity leave, if they are dismissed for whatever reason after 6 months, it could become an automatically unfair dismissal. Another day one right in terms of flexible working. Currently, people can already make the application for when they arrive straight away, and they can make 2 requests a year. This was an opportunity for the government to significantly change the rules on flexible working. I think many employers will be thankful they didn't, because you probably are aware, currently there are 8 statutory reasons for refusal, and they're pretty broad. And if you do want to refuse a request for flexible working, you usually can find a reason, for example, cost to the business, or impact on quality, or impact on colleagues. And at the moment, an employee can bring a claim under the flexible working rules, but only if the process hasn't been gone through properly. What they can't do is bring a claim because they don't agree with your reason for refusal. The change here is subtle, but it's quite significant in that the focus is on refusal. So it's still a day one right, obviously. You can still make 2 requests a year, but now an employer has to show that unless it's reasonable to refuse, they must allow the request. So if you see there is a significant change in the focus there. They have to explain the reason, explain why it's reasonable to refuse, and set it all out in writing. So the 8 statutory reasons remain in place, but you'll have to consider what your justifications for refusing are. And the focus is now on you, the burden is on you to show that it's reasonable to refuse. Fire and rehire. I'm sure you all remember the furore over P&O's decisions a couple of years ago to just dismiss a significant proportion of the workforce because they wanted to change their contracts of employment or the terms. And it was cheaper for them to do that and to run the risk of the claims that arose, and also to significantly annoy their union, than to actually, they save more money putting them on the new terms. So currently, where an employer dismisses for refusing a contractual change, so they want to change the contracts, the employees refused, and they dismiss them for that reason, which is what happened in the P&O case. They then offer new contracts, and if there's a legitimate business interest to do so and they go through a consultation process, that currently is a fair dismissal. There is a statutory code of practice around fire and rehire, which is relatively new. No one really takes much notice of it. But at the moment, you can do that. And moreover, if you offer new contracts to your employees and they refuse, when they bring their claims for unfair dismissal, you can say that they failed to mitigate their losses by refusing the new job for which they'd be paid, albeit at a lower rate. The change here is that it's automatically unfair to dismiss, so they don't even have to prove the fairness of the dismissal. They only have to prove that the reason for their dismissal is that they've refused to agree a change, or the reason for the dismissal is to enable a re-engagement of someone else to carry out the same role. That's quite a significant change in terms of employers who want to change employment terms. And what isn't clear at the moment, and hopefully it'll come out in consultation, is to what extent this extends to any kind of contract change. Because at the moment, if you want to change, as I've said, if you want to change contractual terms and your employee refuses, you can say, we're going to implement it anyway. They can resign and claim constructive dismissal, but it will be a fair dismissal. That will all change under this. So there is a high bar here. And employers can only fire and rehire where there's no alternative. There is an out where if they don't do it, they're going to be significantly financially impacted. But then you get problems, I think, in getting tribunals to make a decision on what significant financial impact means. They're not able to do that, or they certainly don't do that at the moment. They don't. It takes them into new territory, having to make judgments on financial and commercial arguments. So this is worth watching because it will impact on contract changes generally. 0 hours contracts at the moment. Now, the Labour government hate 0 hours contracts, and they wanted, or they have threatened for a long time, just to outlaw them altogether. They call them exploitative. That hasn't happened. So you can still have 0 hours contracts. I think they had to backtrack because they realized that actually it suits many employees and certainly many employers to have the kind of ad hoc hours contracts that 0 hours contracts permit. You can't obviously tell somebody who has a 0 hours contract that they can only work for you. Exclusivity clauses are already banned. The change is, therefore, that although we've escaped an outright ban, employers have to offer guaranteed hours contracts that reflect hours regularly worked over a reference period. We think it'll be 12 weeks, but that will be set by secondary legislation. Also, employers have to give reasonable notice of shifts, of cancellations of shifts or changes of shifts. We don't know what reasonable notice means, and that will again come out in consultation. So what this means is that if an employee wants to have a guaranteed hours contract and they've worked for over 12 weeks or whatever the reference period ends up being, they can ask for a guaranteed hours contract, and then the employer has to turn their 0 hours contract into that guaranteed hours contract. Furthermore, as I've said, if you don't give reasonable notice of shifts or reasonable notice, moreover, of cancellations of shifts, that could entitle your 0 hours employee to compensation. It'll be capped compensation, but it'll be compensation nevertheless. The government have said where work is genuinely temporary, there'll be no expectation on employers to offer permanent contracts. They've also promised that workers who wish to remain on a 0 hours contract will be able to do so. But this is going to make it a bit more problematic to operate 0 hours contracts. So what kind of things can you do to mitigate this and steps to take now? You can model what a new contract looks like, reflecting hours that are regularly worked. You can consider operationally what right to reasonable notice of work schedules and wages for shifts cancelled at short notice could look like for your business. You could check your scheduling and your tech to make sure that it's fit for purpose. You could review how to manage seasonal fluctuations, either through hiring temps or offering overtime to regular employees, if you believe that there's going to be a problem. Sexual harassment, it's already changed, 26th of October. There was a significant change in the law, but that is going to be extended. So at the moment, under the new change, employers must take reasonable steps to prevent harassment by other employees. There is, at the moment, no liability for third-party harassment, i.e. not by other employees, but by customers or contractors. The change then, and it looks small, but it is significant. The rule is that you must take all reasonable steps, and that word all was hotly debated in Parliament last time round. They're bringing it back because all reasonable steps implies that there will be steps that you must take. Now, there is information out there about what they look like, but that remains to be seen. But it does put a new, more onerous duty on employers to take all reasonable steps to prevent harassment. Significantly as well, liability for third-party harassment will come in. So if your employees are harassed by customers, then that could make you as an employer liable. And also any disclosure about harassment will become a whistleblowing disclosure. We'll get regulations specifying what steps you have to take, new reporting channels, new complaints procedures, risk assessments, communications to third parties, but we don't know very much what that looks like. I do have a couple of tips though on this. There is the Human Rights Commission's 8-step guide, so it's worth having a look at that and considering how you can implement them if you're not already. You should be making sure that you're completing sexual harassment risk assessments. You should be delivering sexual harassment training to all managers, certainly, and to all employers. You should be identifying ways employees can disclose harassment. You could think about identifying champions within the business. I picked that up. I'm not really sure exactly what that means, but in the same way that you have mental health champions, perhaps people who can be trusted to manage the kind of disclosures and deal with these issues, and start to consider how to prevent harassment by third parties if that's relevant for your business. National minimum wage is going to change in that the age bands will be removed. So the same rate is going to apply to all workers aged 18 or above. Now, the national minimum wage rose to £11.44. And with the budget, it's going to go up to £12.21, which was a 6.7% increase. This bill specifically says that 18 to 20-year-old rates will go up by 16.3%. So reforecasting your salary bill for April 2025 onwards, which is when all this will come in, is essential. And I'm sure you're doing that already. You could also look at your employee benefits and total reward strategies and other people-related costs. But this isn't an accounting seminar. That's all I know about that. But I'm sure you'll be thinking about that already. And then what's ahead? Quite a lot. The government have played with the idea of the right to switch off for quite a long time. And it's actually quite significantly advanced in Europe. And quite a few European countries already have this. So that is the right not to be contacted by your employer after work or outside work hours. There will be a code of practice on this, and we don't know what this will actually look like in real terms, but it's worth being aware of. Extending equal pay rights and pay gap reporting to ethnic and disabled employees. This will be a thing. It's going to enshrine in law the full right to equal pay in the same way that it exists already for gender, which actually has since 1970. So it enshrined in law for the right to equal pay for ethnic minorities and disabled people. It will introduce mandatory ethnicity and disability pay reporting if you've got more than 250 employees. And it'll extend equal pay rights to protect workers suffering discrimination on the basis of race or disability. They already can bring, disabled employees, for example, can bring discrimination claims, but a discrimination claim is a very different beast from an equal pay claim with different rules around compensation, etc. And equal pay claims can go back a significant amount of time. They've promised a full review of the parental leave system and of carers' leave. They've just dabbled around the edges with these new changes. But I think in the next 4 years, there will be a new review, a proper review of the leave systems. There'll be consultation with employees and trade unions around surveillance technologies to consult on how to implement surveillance technologies further in the workplace. There'll be consultation on a simpler framework for employment status. I'm sure you're all aware of the difficulties of identifying whether someone's a Limb B worker, self-employed, an employee. That hopefully, and it's well overdue, will become clear. This is consultation only. It might take quite a few years to get to the happy stage where you absolutely know your employment status from the minute you start work. There'll be an examination of issues relating to the TUPE regulations. TUPE needs an overhaul. The regulations and the process are incredibly complicated. Health and safety guidance as well will be reviewed and modernised. Its structure will stay the same, but they'll be looking at things like extreme temperatures, which aren't covered very well, long COVID, neurodiversity, and those newer issues. There'll be consultation with ACAS on enabling employees to collectively bring grievances through ACAS. Of course, they can already just through their employment, but they will be able to do that with ACAS. And tightening the ban on unpaid internships. There is more, but I've just wanted to concentrate on the things which are likely to come in because the Labour government have been talking about them for a long time. Now, that is really whistle stop. I'd be really happy to, if you want to send me any questions, I'd be really happy to answer them. But it is a case of wait and see with this. It's going to take at least a year, if not more, to get further clarity. There's quite a lot you can do, as I've pointed out, some of those ways anyway, to prepare for it.
Thanks, Kate. If you would like to learn more about the recent changes in employment law or how a part-time legal director could benefit your business, please go to our website, thelegaldirector.co.uk.